The 6-3 conservative majority Supreme Court just kicked off its newest term at the beginning of October. And the big question headed into this term is, what kind of trajectory is this conservative-dominated court going to be on? Everybody recalls that the court just last term handed down some really earth-shattering rulings, including overruling Roe v. Wade and getting rid of the almost half-century-old right to abortion that existed as the law of the land across the country. What's clear is that the conservative supermajority has an ample appetite to take on conservative agenda items that for decades members of the conservative legal movement have wanted to see the Supreme Court act on, and to bend constitutional law in a rightward or conservative direction. The big question now is the court going to continue moving in an aggressive direction to the right? There are some big cases this term, including a case that tees up the question of affirmative action in admissions policies in colleges. The issue in this case is whether the court should preserve a longstanding precedent that says colleges and universities can use race as one factor when making admissions decisions, or if this is something that the court thinks has outlived its legal timeline. The challengers here have asked the court to overrule Rudder v. Bollinger, which could have really broad implications for higher education across the country. The court is also considering narrowing, potentially, the Voting Rights Act. This is a case that came out of Alabama. Alabama has 7 seats in the U.S. House. Based on its demography, its black population should account for a majority of about 2 districts. Well, right now, there's only 1 U.S. House seat that accounts for majority black district. So challengers here said that this map, as it was drawn after the 2020 census, violates the Voting Rights Act.
It's simply not fair.
A group of Alabama Republicans have asked the court to essentially narrow the Voting Rights Act and say that unless there is evidence that the electoral maps in Alabama were drawn with racially discriminatory intent, their current voting maps should be allowed to exist. Another case on the docket looks at LGBTQ discrimination. This is a case that comes out of Colorado. It's based on a wedding website designer who made a plan. She was going to announce in her marketing materials that she would decline to make wedding websites for same-sex couples. This was challenged under Colorado's anti-discrimination law. This isn't a religious rights case necessarily, although the reason why the wedding website designer said she would not offer her services to same-sex couples is because of her religious beliefs. But really, this is a question having to do with First Amendment speech protections, where the issue here is whether somebody like this web designer can be forced to offer her services for same-sex couples when same-sex marriage is a position that she opposes, and that's going to be handed down probably in late June, maybe early July. Another case on the docket has to do with election law. This is a case out of North Carolina. What's most interesting about this case is just how broad the legal argument is that North Carolina Republicans have proposed to the court. They're asking the court to look at 2 parts of the U.S. Constitution that deal with states' rights when it comes to setting procedures and rules for carrying out federal elections. And the kind of maximalist argument that they're making here is to hold that only state lawmakers, so not state courts and not governors, only state lawmakers have the power to determine what a state's rules will be governing federal elections there. Now, if the court does this, it will have major implications for things like gerrymandering, because in effect, if the state legislatures moves when it comes to how it handles elections, if that is not something that can be reviewed by state courts, and recall that federal courts have already said we don't have a role in gerrymandering claims, then what we would be looking at would be state legislatures having just carte blanche to create maps that can skew voting districts in a way that could give a real partisan advantage to one party over another. And finally, there's a big case that has to do with the government's scope of authority under the Clean Water Act, and specifically whether or not the federal government can regulate wetlands, and what kinds of wetlands are the kinds that fall under the regulatory scope of the federal government. Do they have to be touching waters that are considered navigable waters of the United States? Or can these wetlands have some less direct contact, maybe underground, where the discharge of pollutants into these wetlands could eventually reach the waters? Is that enough of a jurisdictional hook to give the government power to regulate those? It's another case with big implications for the scope of power of the federal government to regulate the environment. We're going to be seeing some big themes that could come into sharper focus this term at the court. The conservative 6-3 majority on the court is clearly showing an appetite to take on big cases and to steer constitutional law in a conservative direction. This is coming at the same time that one public opinion poll after another consistently shows that the Supreme Court is suffering from the loss of legitimacy. You're seeing public opinion polling showing that Americans have less faith in the court. Increasingly, large numbers of Americans think that the court is making its decisions based more on politics than on their interpretation of the Constitution and the law. We've already seen some signs that this could lead to blowback at the ballot box. There was a ballot amendment in Kansas that was defeated that would have basically mirrored the overruling of Roe v. Wade at the state level. That was soundly rejected by voters. And we may get more signals about just how Americans feel about the overruling of Roe once we see the midterm results start to roll in. The court is still filling out its docket. There are thousands of petitions that are sent to the court each term, and only a small sliver of those get placed on the docket. The question there will be, how much of an appetite does this court have to move things in a very fast and very far conservative direction? It only takes 4 justices to agree to hear an appeal. This means that 4 of the most conservative justices on the court really have a free hand to choose which legal vehicle they want to take if there is an agenda item that they want to push. So there's a possibility that the court takes on some additional big blockbuster cases this term. Most court watchers think the court is going to decide these big cases in a way that it breaks along ideological ground, where the 6 or in some cases maybe 5 conservative justices will line up on one side of an argument and the liberals on the other. And this has huge potential to really reshape American law in fundamental ways.